Hi everyone, thanks for joining me again. This is going to be the second video for our course Business Law. Hopefully by now you all were able to purchase the book for the Business Law, the Business Law and Strategy book. Today this video is going to cover chapter 1. Hopefully you all read this, and I think once you read it and then following the video along, I think it blends in better and helps you understand the whole chapter. So hopefully you read it. If not, I would encourage you to pause the video, go read chapter 1, and then watch this video discussing the chapter 1 with me. Okay, well, let's get to it. Now this is the second slide of our PowerPoint presentation. I just want to note that this PowerPoint presentation is available in Blackboard. So if you want to print it out or you want to see it electronically to follow along with me, that would be great as well. The second PowerPoint here is going to be discussing our learning objectives. Now, first, we're going to learn how to articulate a working definition of law and explain its basis. We're going to categorize various laws and articulate the functions of the laws and the legal systems. We're going to explain the importance and the benefits of legal awareness for business owners and managers in creating strategy and adding value to the company in the role of the general counsel or counsel within that company. We're going to differentiate between and provide examples of primary law and secondary sources of law in the American system. And we're going to apply the legal doctrine of stare decisis in a business context. Now let's move on to the other slide. Now we go into slide number 3. What is law? The law is a body of binding rules of action or conduct by controlling legal authority. Now, the American law, as we know here, is established by our legislators, which are our state elected officials, or it can be federal officials, as well as our local authorities making the laws for us. Now, this at times when the law is vague, then whether it's federal, state, or local, those laws can be interpreted by the judges or by the courts. So the law creates duties, obligations, and rights for individuals as well as companies and employees. Now the law is classified by subject matter. For example, there's rules regarding agreements that is classified as contract law. And now rules governing the rights of employees or employers with those employees, that's under employment law. Now there's one sentence here or one paragraph here I did want to note that I believe it was very important, especially in a class for business law, whether it's employees or whether it's a company looking to establish what direction they need to move. Now, if we look on page 3 under Introduction to Law, and I'll read this because I thought it was very well written. Now, most importantly, in the business environment, the law provides a mechanism to resolve disputes arising from those duties and rights, and allows parties to enforce promises or agreements or contracts in a court of law. The law is often classified by subject matter so that one refers to certain rules or agreements. Now, what that is saying now here in this country or in state, we have duties or rights. So when we enter into agreement or into a contract, a binding contract, which we sign, then both parties are bound by certain responsibilities. Now, the contract can lay out the responsibilities, but the courts also have a dispute mechanism for what if one of the parties does not perform his or her duty in that contract. Then there's a breach of contract, and then there's consequences, which we call damages or monetary damages, which is just money consequences that a judge may put a judgment order against one party. So not only do we have the rights to establish a contract, but remember we also have the rights to establish what if one party is not performing their duties or their responsibilities with a contract. Then we have mechanisms how to file a dispute and get perhaps maybe a remedy by a court. Now, because our legal system is very broad, whether it's a state laws or federal laws, it's easier to break them down based on categories or classification. as in PowerPoint number 4, there's the categories of laws. There are several, as you can see. There's criminal, civil, substantive, procedure, public, and private. And that's just limiting those that are broad. Now, the purpose of criminal statutes or criminal laws is, I'm sure as y'all can guess, is to protect society. Examples of this can be homicide, robbery, theft, things of that nature. Now, a civil matter is those to compensate parties for loss of damage or loss of property, some things of those nature. Negligence that causes personal injury, perhaps maybe a civil suit. There's substantive law that provides individuals with rights and certain duties. Now, an example of that is a state law that permits a business or an individual to recover losses in perhaps maybe a shipping contract. Now there's the procedural parts of the law that structure the rules for ensuring rights. For an example of that may be a state law that sets out a time period which an injured party or which someone can file a lawsuit. For example, if there is a breach of contract and perhaps maybe the injured party wants to file a lawsuit against the party who didn't perform his or her duties, then the court won't let you just hold on to that contract and say, you know what, I'm going to file a breach of contract lawsuit maybe whenever I get the chance. I'll file it maybe in 5 years, 6, I'll get around to it. No, then the procedural standpoint, then there's generally a statute of limitations that the court will say you have 4 years from the date of the breach or when you should have known the breach, you have 4 years to file that lawsuit. If you don't file the lawsuit, then in the procedural standpoint, you can come back 6 years later and file the lawsuit and say, you know, there was a breach of contract, so-and-so never performed, now I'm suing for $20,000. Then the courts will say, based on the procedural laws or the procedural rules, you already passed that timeline, the statute of limitations, those 4 years when you had a right to file. Therefore, now we're going to throw out your case. Whether that person was guilty or innocent, you don't even get your day in trial. They won't even hear it. Then that's from a procedural standpoint. Now, there's the public laws, which are established by a government entity. Now, examples of those are federal statutes, the Patent Act, or state statutes, which they establish the right of a corporation or a limited liability company. We'll get those later, and we'll get to those later in the chapter. But every company is created in a state, and that's usually by filing with your Secretary of State, and those are state laws that are going to create the company. Now, there's also private agreements, and those are arriving from a private agreement between two parties, and that's generally between a contractual obligation between one party and the other. They're going to it's usually contract for services between a vendor or a business, and I'm sure plenty of us have gotten into contract, whether buying a car, getting a service, a lawn mowing service, or whatever type of service we'd come across. Then that's a private agreement between you and the other individual or the other company to provide a service or to receive a service. One thing I did want to add in a continuation from the previous slide, number 4, which are the categories of law, I did mention that we break down the law into areas or concentrations, whether it's criminal, civil, substantive, procedure, public, and private. I did want to note that these are not mutually exclusive. They can commingle and go together. An example of that is perhaps maybe the easiest one I can think of is a DWI case. If there's someone is driving under the influence, being intoxicated, then they are obviously creating a criminal breach. So they are not going. It is for the protection of society, as driving intoxicated is not for the protection of society. So you will all be prosecuted in criminal law. However, if that individual crashes into another individual and injures someone else or damages property, then at that point, that individual who was intoxicated will face criminal prosecution for the DWI, because that is a criminal offense and it is against against society. But it will also combine with a civil lawsuit, which will most likely be for a personal injury suit when that intoxicated driver hits another car and injures that person or those people in that car, then they will have a civil lawsuit against that driver. So it would be most likely for damages, monetary, for money, and it would be most likely combined with the criminal. So the individual may serve perhaps maybe jail time or face criminal charges, but there will also be a civil suit, which will most likely result in him paying out of pocket, or his insurance paying that injured party or parties. Now we're going into slide number 5, the language of the law. Now, as I'm sure you know, legal terms have specific important meanings to them. So if there's a certain law, then the way the words are placed or the specific words they use, they have meaning. It is very important. Now, as business law students, you have to learn the terms, how the law is interpreted, as well as, which is just as important, how to apply those laws to specific situations, or perhaps those of you who are employed or who are going to be employed, you have to learn how to apply them to your specific situations to make great decisions for the company or for your managers, or whatever situation you're in for the company. Now, American law uses terms from early and modern English, French, and Latin. That's how sometimes some words, the way they use them, they're not, the laws the way they're written are not generally the way you and I speak all the time, but it's because they're derived from different languages as well. Now, there's a dictionary called Black's Law Dictionary. That's the authoritative source for definitions for if there's a statute or a law and there's a specific word that you want to know what that specific word means, and from a legal standpoint, then Black's Law Dictionary is the source to go to for a specific word that you want to know how it is interpreted or applied specifically when used for statutes or laws. Now, slide number 6, functions of the law. Now, the law provides a system of order to define rules of conduct, to punish violations of those rules. It is to promote justice and equality in society, especially in education and the workforce. Two areas that touch the majority of us, which is the workforce and the education. It also provides a system for resolving disputes, as we previously mentioned, involving legal interests, which can be perhaps maybe business or individual and their rights. Now, it serves as a catalyst for commerce by providing good faith dealing among merchants and consumers, and giving some degree of reliability for business planning and commercial transactions. Now, that's to say if everything goes well, but generally when there's contracts involved, there's not 100% guarantee that all parties are going to fulfill their obligations. So it at least gives businesses here in the US and in our states some sort of good faith dealing, which generally means there is some sort of faith that if I ship a certain product to you, then you will pay me X amount for that, and there is a contract that states that. So at least in the US, we have a right to resolve those disputes, which are the courts. I mean, nothing is guaranteed, whether it's the contract or the courts, but we do have some sort of good faith dealing that if one party does not resolve or one party does not fulfill their rights or obligations, then there is a way to resolve those disputes. Now, slide number 7, defining strategy in the context of law. Some recent law trends for businesses are these 6 in the bullets that I put here. Now, there is an increased U.S. regulation, meaning there's constantly more laws being placed on businesses. We generally see that a lot with the banking industry. The banking industry is an industry that is highly regulated, which of course it protects our money, it protects our savings accounts and things like that, which there is reason for it to be high regulated. Number 2, the differences in international trade and intellectual property. Third one is there's high and strict penalties for non-compliance. For instance, there's a company that was found to have false advertising in their products that they were selling. They were hit with heavy penalties. There's increased officer and director liability. One of the things that is increasing dramatically is the protection of consumer data. So basically consumer breach, cyber attacks, how those companies are being proactive to protect from any types of those attacks, which generally lead to a lot of leaked data of consumers' personal information. So there is now liability that they want the directors or the owners to have if there's some sort of breach where all of the data is leaked or made public. There's also been a major increase in attorney directors for U.S. corporate boards, meaning the board of directors that generally guides the company's direction. That's now up to about half of the board of directors for all U.S. companies. Half of them are attorneys. So we've had a high increase in attorneys board of directors. That's generally because attorneys understand the laws. They know what direction we need to go and add strategy to those laws. Now, one changing legal landscape that I'm sure we've all been affected by is the changing landscape for businesses, for the laws, especially related to COVID-19. When the pandemic hit, when COVID hit, there was a lot of laws that employers or businesses were trying to work with. There's of course mask mandates. There's of course employees that we have to deal with. There's customers. There's vendors. There's supply shortage issues. There was a lot of things that companies had to adapt to survive, and most of those dealing with COVID were difficult. Some made, some thrived. Some were able to adapt and move fast to adapt to the landscape and make the changes necessary for the employers, the customers, the vendors, all of those. But as I'm sure you're aware, some companies were not able to adapt and perhaps maybe went out of business or did not survive or saw a large market share loss of their company. But during the COVID-19, there was a lot of laws that came about, and they came about fast, that employers needed to adapt and needed to apply in their business. Now, one point I did want to say, when you're in the business, and whether you're perhaps maybe a manager or you're an employee, one of the main, I think I mentioned before, a main concept to know in business law is not necessarily just knowing the law, is not necessarily the final step. It is applying that law, how to apply that law to your situation, to your circumstance, how to apply legal theories. Now, I'm going to quote here on page 5, knowing the law and knowing how to apply the law to your business, to your issue, or to the problem that you're currently facing in your business, that's going to empower business owners and managers and employees to limit the liability. Now, when you limit the liability of a company or an employer, then you gain a competitive advantage over the market or over your competitors. And that adds value to not only you as a manager who came about and presented that advantage, but it adds value to the company in whole. So you must, I would push and pressure you to not only know the law, but know how to apply it, because once you combine those and you know how to apply that to a specific situation or a specific issue, then you become a very valuable person in that company, as well as adding value to that company. Now, slide number 8, we're going to be using strategy in legal decisions. So basically, it's applying the law, how a business can make that a business strategy. Because strategy is a set of guideposts created to achieve an overall objective or a goal that a company wants to reach. The legal environment, it's definitely uncertain because there's unlimited resources. We can't have everything we want. We can't have 100 attorneys on our team to make sure we cover every single issue or every single problem or pitfall that we may encounter. There's opportunistic behavior, which saying obviously we always want to achieve more. We're going to add value to anything we do. And there's information that at times one party may have over the other, or some information is not guaranteed. It's data driven. It's also some of the data we receive is opinion based. So just judging that, there are going to be four major categories of legal strategies. There's one which is just strictly non-compliance, which is you're just not going to follow the law. Some individuals believe that not all laws are followed because not all laws are enforced. So they may take the risk to say, we believe we know the speed limit is 70 miles an hour on the highway. However, I want to be early to my meeting. I don't want to be late. Therefore, I'm going to go 80 miles an hour, 90 miles an hour, because I'm willing to risk and I'm not going to comply with the speed limit for the benefit of what I want. So that's just strictly non-compliance. That may be a strategy. There's avoidance, which is just strictly not going into that industry or that regulated where the law is heavily regulated, then they just avoid it. And there's prevention, which they deliberately go around and not do those specific patches of laws. And then there's the fourth one, which I believe is the most important one. There's the value creating or the legal competitive advantage. Now, there's a way for individuals or for lawyers or for business law students, once they graduate and get into a company, then they know the law, they apply the strategy into a specific situation and gain a competitive advantage for their company or at least over their competitors. Now, I did want to read a line from the book again. It's page 6, Strategy versus Tactics. Strategy, we know it's a set of guides and principles used by businesses to achieve overall success, or at least one part to achieve overall success. Now, we know that business owners and executives, then they're going to deploy tactics which are used to achieve those objectives. And here's one example here on your book. For example, if the board of directors of a corporation strategizes to decrease costs by reducing claims, meaning lawsuits against them, they may want to enforce or decide to put a waiver limiting those liabilities. Now, perhaps maybe they want to go into that sector or go into that line of business. However, they know perhaps maybe it is a risky business, or it's a business that has or may have a lot of lawsuits against them. Now, a value creation or a tactic that we know the law, we know that the law says, if certain things happen, we may get sued. However, we also know how to apply, how to add value to that law. Now, perhaps maybe we can add or cushion ourselves by adding a waiver that's saying, the laws. If you ride a roller coaster, or if you're going somewhere that you're going skydiving or things like that, there may be waivers that they make you sign to say, that there is an assumption of the risk. There is a chance that you may get hurt during this activity. Now, they may still go into that. The business may still, fly you up and make sure everything goes well and parachute. But they know, for instance, if you're falling down and the parachute opens, but you're going to land going skydiving, there is a chance you get hurt on the landing. Now, there is a way for companies to limit that risk, to say, there's a risk. There's a chance that you're going to land and hurt yourself or things like that. So they may limit them. They may go into that industry, into that business, but however, they limit their exposure or their potential for liability by having waivers. Now, that's a way to add value to the company. Say, let's go into that business, but we know how to add value by having a waiver to limit our liability. Now we're in slide number 9, the role of the business counsel. Now, the role of the business counsel usually falls on what the companies call the general counsel. And that usually means the attorney for the company. They're usually an executive or mid-executive level, and they only represent the company. That most attorneys practice in law firms, and they have several clients that they represent at several times. However, when you are a general counsel, then you are the attorney for inside that company. So you're an employee for the company and you only represent the company. And that's the role of the general counsel. Now here I've listed 7 bullet points where some summaries of what the general counsel or the counsel does for the company. Now, one of them is assist management by reviewing the legality of their decisions. Meaning, when someone, usually when there's executives or managers saying, if we go one direction, what is the legality? Can we go that direction? Or is it legally, are we compliant if we follow one direction? Then the role of the general counsel would be to go back, review the laws, and perhaps maybe if the way they want to achieve that strategy is not necessarily a legal way, then he may present other decisions or other opinions to say, I know you want to go in that direction, but perhaps maybe we need to take a different road, a legal road to get to the point where you want to go. Or perhaps maybe if we want to go that direction, when you just need to change the vehicle because it would be legal or more legal and less risky, we do certain things. But that's usually the strategy. They review the legality of the decisions of the management or executives who makes those decisions. The general counsel or counsel also is going to advise on the strategies to ensure compliance is taken and to avoid violations, meaning any penalties or fines if they go a certain direction and they're found to be non-compliant or they're found to be in violation of the law. Then he has to advise on those before going in that direction. He's going to analyze the impact of the law and the law changes in the company. He's going to produce, and meaning he's going to draft and he's going to create the documents and file the required documents, whether being with a state entity, with a federal entity, or local ordinances or local counties, or perhaps maybe federal. But usually the general counsel for the important legal documents is going to be the individual in the company who's going to create them and file them, as well as communicate with any of the entities or the authority on any revisions and things like that. He's going to defend the business in before courts or regulatory bodies, which is the government, for any violations or potential violations. If there's any lawsuits, then he or she will defend the company as well. He's going to pursue court relief for violation of the company's damages. So if there's any damages that the company created, or perhaps maybe the EPA, Environmental Protection Agency, if, for instance, the company was found to have polluted a certain pond or something like that, then the attorney or the counsel would usually be the liaison, going back and forth between the Environmental Protection Agency and the company to make sure that everything that they found the violations are cured for and satisfactory of the EPA. Now, lastly, the general counsel or the counsel is also going to lobby the legislators, which are federal, state, or local, and he's going to lobby for changes in public policy or changes in the law that he believes are not in good standing for his company. For example, if there's something that he believes is overly burdensome and unnecessary, if there's a law that he thinks like that or she thinks like that, then he may lobby the legislators or elected officials to say, hey, there's this law. We understand it requires my company to do A, B, and C. However, I believe C is unnecessary. It's overly burdensome. It costs too much. There's no point to that. Then he'll lobby to remove C from the law, and he'll lobby and he'll show why it's not relevant. It's just unduly burdensome and things like that. But that's one of the last reasons. One of the last responsibilities of the attorney is to speak to the legislators to describe what type of changes he or she would like in the law. Now, in slide number 10, we're going to continue with the primary sources or primary source of the American law, which is our constitutional law, which is the Constitution of the United States. Now, that Constitution is going to establish the government structures. It's going to grant specific powers to the government. It provides for rights and procedures for businesses and entities, and as well as individuals. And every state has its own constitution. In addition to this federal constitution that we all have. Now, these states' constitutions serve a similar role or a similar function as the U.S. Constitution, as long as they're not inconsistent or somehow run afoul with the federal law, which is the federal constitution. Now, constitutional issues affecting businesses include the Congress's power to regulate interstate commerce, to regulate commercial speech and have limitations on state authority and regulate tax procedures and services. Now, here in the United States, I'm sure we all know that the Constitution is the law of the supreme law of our land in the United States. Now here we're in the slide number 11, the case Kellow v. the City of New London. Now, just a quick little background, and I'm quoting here, and I'm reading here from the book here on page 8. Now, Kellow moved to New London in about 1997. She made extensive improvements in her house, which was there in front of the sea to have great views on the property. However, that city was in a long time in economic decline. So there was no businesses, and all the businesses were leaving, and perhaps maybe the residents were leaving as well. So the economy in that location was in a decline. These conditions prompted local authority, which is the city council members, to create an economic development plan, which how to reestablish the city, or how to try to bring it up, and usually bring it up by attracting big businesses and attracting people, hotels and tourists and things to come into their city, spend money in their city, so they can spend money with their business owners and to the city. One of the plans, they had created a plan to lure a business, and I believe it was Pfizer. Pfizer agreed to build a $300 million research facility there in the city. However, the city would also need to create some sort of commercial, you would say, complex or centers around the business. So the city council did approve. They created the New London Development Corporation, which was a private nonprofit company, to acquire properties around the Pfizer location for hotels, for parks, for businesses, for restaurants, something to bring up the community, invest in it, and hopefully the Pfizer with their new facility would bring a lot of jobs. And what they wanted was, I want Pfizer's, I want to come here, but I want to come here to great development and things like that for the employees. So they agreed. Part of the NLDC, the New London Development Corporation, was to purchase the parcels of land, or the pieces of land around Pfizer, to be able to create this development, for which would be used for public use, because there would be parks and all those businesses would be available to the public. The company, the nonprofit, was successful in purchasing most of the lots. However, one of the individuals, Kellow, did not believe that this was right. The city of New London, filed suit, and ultimately it made its way up to the Supreme Court. They said Kelso was arguing that no private property can be taken for public use without just compensation. Now, they were arguing that this case wasn't for public use because it wasn't necessarily they weren't going to build a highway, or they weren't going to build a street on there. So the case revolved around eminent domain, when the government has the right to take your property for just compensation, for fair market value or for money wise. But the court held that it was, what they were doing was for the purposes of the economic development. And I'll read the slide. The city of New London, Connecticut, had the constitutional authority to take a homeowner's property for just compensation under the Fifth Amendment, even if the city's purpose was for economic development rather than the traditional use of projects such as highways. Now, this is one example how the Fifth Amendment, that you can take property for public use. This is one of the cases that established it, that it necessarily doesn't have to be a specific highway or something that is very clearly for public use, but economic development for the use of the whole city, for the use of the public, falls under those rights for the city or for a government entity to take property from an individual owner for just compensation. Slide 12, primary sources of American law. Now, American law doesn't have just one law, meaning the Constitution doesn't cover every single situation. Now, from the Constitution, it does go down to your specific ordinance, or what we call maybe local government laws. Now, at the top, we do, as we mentioned, we have the U.S. Constitution, And as we mentioned, every state has their own constitution, which is amended more frequently than the U.S. Constitution. Now, from a top-down approach, there are federal statutes, which are federal laws. Then there are state statutes, state laws, and then then underneath the state statutes there are local government. So there are perhaps maybe your county, for Bexar County ordinances, and then there's maybe city codes or city laws. So there are several laws. There's the U.S. Constitution, the state constitution, the federal laws, the state laws, and then the Bexar County, and then perhaps maybe city. But before that, I wanted to mention that federal statutes, the way they get created is through Congress. So your elected congressmen and state representatives and federal senators, those are generally the ones that will vote and pass federal laws. Same thing for state representatives. There are state representatives and state senators. They're usually the ones that try to or put forward a bill, which is before it becomes a law, it's a bill which you're proposing to the House or to the Senate, which is basically their legislative body for everybody to vote on and to see if it will become a statute, a law, whether it's federal or state. Now, slide 13, continuing on the primary sources of American law, we're going to discuss now the administrative law. Now, in statutes, governments, or perhaps maybe the U.S. government, delegates rulemaking authority to executive branches or executive agencies and independent government agencies. Perhaps maybe an example that we all know is, we all know that the U.S. government has a right to tax, or basically we pay income taxes. The money we make, part of that we pay to the U.S. government. But the U.S. government delegates those laws, those rights, and how an agency is going to interpret them to the Internal Revenue Service, the IRS. So the U.S. government has the right to tax, but all those rules and the laws, they pass it to the IRS. And the IRS are the ones who are going to enforce the taxing authority that the U.S. government has. Now, pursuant to statute, agencies are empowered to administer the details of federal statutes and to impose those regulations, make policy, and enforce the law in their area of jurisdiction. So they may enforce the law, basically the IRS, when they say, if you're delinquent in taxes, you're not paying taxes, the IRS is going to come after you, as some people say. What they mean is that power or authority has been delegated from the U.S. government into the IRS. So when they say the IRS is the one coming after you, it just means that the IRS has the authority to enforce those laws of taxing. Now, courts are also highly differential to agency decisions involving how and when the agency enforces a regulation, meaning the agency generally has the power to write the rules. If there's a law, then they'll write the rules and how to interpret that law. Now, the other slide, slide 14, which continues on the primary sources of American law, we're going to talk about what is called common law. Now, generally, most states, we're based on English common law. Now, this is often referred to, I've heard it referred to as judge-made law. Now, it is direction from hundreds of years of precedents, meaning hundreds of years of decisions already made by other prior judges going how to interpret a law in their courts. Now, precedents means judges apply the law from previous cases with substantial similar facts to your certain case. So one example of this, and this may not be the best example, but I'm thinking how we can make judge-made law is, for example, if the law states, and get this, I'm just paraphrasing and just summarizing here, but if the law states, in order to have a binding contract, there must be there must be an offer made, and then that offer must have been accepted, right? But sometimes laws, they don't all state what the offer means or what acceptance means. So someone may write a contract. It's, everything is correct. I offer you, I'm going to, mow your lawn for $20. Now, I may have a contract, I sign it, and I give it to you. And I'm the one wanting to mow your lawn, so I'll sign, I give it to you. So I think that's pretty clear evidence that there was an offer was made. I wrote the contract, and then I gave it to you. Now, if the law states in order to have a binding contract, there must be an offer, which let's just for argument purposes, I made an offer, but there must be an acceptance. Now, if the law states those two things, and perhaps maybe you as the person wanting to receive the services, you send me a text message. Now, the law doesn't say text messages and you may reply with a text message, but what if I respond to say, Professor Ramirez, your offer looks great, I accept it. And it was through a text message. Now, the law says there must be an offer, there must be an acceptance. Now, the judges may have their own law to say, in this situation, when an offer was made and a clear offer was made, the recipient or the one who's going to receive the service did provide acceptance. And the acceptance was via a text message with the word approved. Now, in that situation, the judge just made a law. If you ever respond and someone gives you a contract signed and an offer made and you respond, approved, go ahead or proceed or something like that, and then I make the actual service, I mow your lawn, you can never say, oh, too bad. I know you made me an offer, but I never accepted the offer because I never signed the contract, so I never accepted it. Then I would go to court, I would sue for the $20, but I would say, Your Honor, Judge, the person accepted my offer, and then the judge would imply, and he would make judge-made law to say a text message suffices or is enough to justify an acceptance, and that is how the law was just an offer and acceptance, but didn't go into much detail. So the judge just made law that a text message is acceptance. Now on slide 15, we're going to discuss examples of laws that impact businesses. Now, just to discuss what we just discussed in the sources of American law, we did discuss three types of sources. We discussed statutory law, which are laws made by our legislators that pass whether at the federal level, state level, local level, which may be county and city. Now, those laws are codified, which we can in books in our statutes. Now, second, we did talk about the administrative laws. Those are the laws that a government entity or the U.S. government may delegate or may provide to another entity or another agency. We discussed an example of the IRS, the taxing authority or the taxing rights that the U.S. government has, that was provided to the IRS. So that's delegated to the IRS, and they provide their own laws and rules on how to comply with the taxing authority. And then thirdly, we discussed common law, which we put here that one of the air quotes here was the judge-made law. We discussed the offer and acceptance, and we discussed how an offer or an acceptance may be interpreted by a judge. Therefore, the judge made the law on how an acceptance. Now, here on this slide 15, we're going to discuss those type of laws and how they may impact a business or perhaps maybe managers or executives. Now, first one, the type of law, negligence. Now that is going to be statutory and common law, and it's going to be primarily governed by state laws. Employment discrimination is primarily statutory and administrative law, and is primarily going to be state, federal, and as well as some local. There's going to be patent and copyright law. That's generally statutory and administrative law, and that's generally going to fall under federal. The contract for sale of goods, that's going to be statutory law, and it's going to fall under state authority. Now, contracts for services, primarily common law. So contracts for services are remember, primary common law is the judge-made law. So the services in several states may be interpreted different by different judges from different states. So again, that's going to be state law, but it's mainly state judge law for contracts providing services. Bankruptcy is going to be statutory and administrative, and that's going to fall under federal. Securities law is going to be statutory and administrative as well, and that's going to be generally federal law, but it may also touch on state law. Now, zoning ordinances, which zoning on how a property can be used or what can be built on there or what businesses can run on that property, that's going to be statutory, and it's going to be local laws. Now, of course, taxes, they're going to be statutory and administrative, and they're going to be everywhere because everybody's going to get taxes. So it's going to be federal, state, and local as well. And that's going to be for the taxes. Now we're going into slide 16, law and equity. Now the difference in between law and equity, it was a wording established back in the day when in England, when with the kings, and they had two courts, a court of law and a court of equity. The court of law will interpret just the law, and it would be just based on that situation to say, you know, this is what the law says, therefore we go that direction. Now there was another court called a court of equity, which generally meant maybe there is no laws to govern this situation. However, the decisions will be made based on fairness. And now, however, now courts combine that the courts are now a court of law and equity. For example, remedies are judicial actions to compensate for a civil injury. But if remedies at law, that usually cover money or monetary damages. They're generally going to be payment from the wrongdoer to compensate for losses resulting from the wrongdoer's conduct or lack of conduct. And that's a simple breach of contract. You didn't fulfill your obligations, therefore you owe me the loss that I had. And that's going to be very simple, just to show the loss that you had in monetary forms. You can show receipts, invoices, you know, things that you had to pay because the wrongdoer didn't do his responsibilities. Therefore, he owes you all of that money back, perhaps maybe with interest as well. Now there's equitable relief. Now the fairness. Now generally this doesn't have to do with monetary damages with money, but it's going to be relief when money damages do not suffice, when they're not enough, or perhaps when monetary damages are not there, or you can't justify them. But they usually require an injunction or a restraining order. Now an injunction can be requiring an individual or a business to cease doing an activity, to stop doing something. Now perhaps maybe they're not damaging, but they will or perhaps may damage you later, and then therefore in fairness the court will order that business or that individual to cease doing a certain activity, or perhaps maybe to not come your way or something like that. But there's also specific performance. Now there may be a situation where I had a contract to purchase an item from you. We made a contract. We signed the contract over the internet. I said, okay, I DocuSigned, I did everything. I'll be at your you made me an offer. I signed it. I sent it back to you. I made you an acceptance. And then I'll be at your shop tomorrow with, the $20 to buy the product. Now, when I show up to the next day, then at that point, the shop owner may say, oh, you know what, Professor Ramirez, you were going to pay me $20, and you're right, we did sign a contract, but someone came earlier today, and offered me is going to offer me $30. Now, I signed with you for $20, but this morning I signed with someone else for $30, and he's coming tomorrow. So now I don't want to sell it to you. I'm going to wait for the guy that's going to pay me $30. Now, at that point, I don't really have a remedy at law, because I didn't lose anything. I didn't have any damage. It's not like I gave him the $20 and then he never gave me the product. No, it's just I didn't lose anything per se. So I may file for equitable relief. I may say first I want an injunction. The court orders him to not sell that until they hear my case. So I may get, okay, there's injunction relief. I tell that business owner he cannot sell the product until he hears my case. I may go to the court. I show the contract that there was an offer and it was signed, and my acceptance, I signed it, and tell the court, now I want a specific performance. Basically, I want the court to order that business owner to sell me that product for $20. So I'm not seeking money. I'm seeking to make that business owner sell it to me. So there's remedy at laws. At law means I'm actually damaged. I have invoices, everything to show you. It may be a car crash. We were discussing that DWI example when the individual came and perhaps maybe crashed into me and injured me. I have all these bills. I have time. I didn't go to work. I wasn't able to provide, all these bills. They backed up. So all those, that's easy to prove that I lost that. So that's going to be a remedy at law. But however, in the example of me signing to buy the product for $20, and then I went to the individual store, he doesn't want to sell it to me for $20 because he found someone else for $30. Then I will go for equitable relief, meaning I want to put injunction, meaning I want to, time out, judge, I want you to not to tell that guy, do not sell that product. And then after I go to court and I win, I want a specific performance. I want you to require him to sell it to me for $20. So there is a difference with those two. Again, in back in the times in English law, they were separated. There was the courts of law and the courts of equity, which are fairness. But now the courts are combined. They're now they're a court of law and equity. Slide 17, secondary sources of law. I thought it was useful to put this slide in the presentation because when legislators or when judges when they're interpreting statutory law, which is the federal, the state, or the local, or applying judicially created law, when applying common law, which is judge-made law, courts also seek to help or look to secondary sources of law to assist them in how to interpret those law. Now, the most important secondary sources of law are here, these 2 bullet points. They're the restatements of law, which is a collection of uniform legal principles found in traditional area of the law. And they're going to be model state statutes drafted by legal experts for state legislators to adopt individually. Now, when we're speaking of secondary sources of law, it is important to note, and I'm going to read this out of your textbook. Now, the secondary sources of law also feature commentary and examples to guide courts in how to apply those laws. They're going to have no independent, no authority, no binding authority. They're just secondary resources for legislators or for courts to use to guide them on how to interpret certain avenues. Now, these statutes or these secondary sources, they're usually drafted by perhaps maybe law school professors or perhaps maybe individuals who have been attorneys for a long time and they're part of an organization. Then those organizations may issue guidance on how maybe a court can interpret certain languages. Now, perhaps maybe going back to the example of the offer and acceptance where I submitted an offer to mow someone's lawn for $20. I signed the contract. I send it to the individual, and now the individual accepted by perhaps maybe when they send back a text message to say I agree or please proceed or yes, I agree with everything you wrote. Please proceed. Anything like that. Even though he didn't sign it, now perhaps maybe a group of experts may write a paper to say, most transactions are done over text messages now. Lack of written agreements or electronic agreements is going down. Now everything is done via an app or via text message. Then maybe the courts will start reading those things and say, a lot of communication is done during text message. Therefore, maybe text messages should be binding on from a contractual standpoint. So they're just secondary sources. They're not binding, but they're great. The legislators and the courts look to them to perhaps maybe have some guidance or examples on how best to proceed with their decisions or their situation that they're going to make a decision on. Now, slide 18 for stare decisis and precedents. Now, stare decisis is going to mean that the courts follow precedents as in controlling, in making their decisions. Now, what that means is saying if there is a certain situation that comes before the court and that judge has already ruled a certain way in very specific situations or in situations that are very similar to another situations he or she has had in the past, it's very likely that judges will stay consistent in that decision making. So, for instance, the example I made, if let's say there was the example where I offered to mow the lawn for somebody and somebody texted me approved in that example. Now, if he rules that was a binding contract, that I mowed the lawn, so that person had to pay me the $20. Most likely, precedent's going to share. It's going to show that if there is a similar situation made or filed, if there's a similar lawsuit filed after mine, that the judge will likely, very, very likely, the judge is going to rule the same way. So now basically the judge put perhaps maybe everybody on notice to say, you know, if there is a situation where you text and you say, I agree, approved, go ahead and proceed and mow my lawn, or go ahead and proceed and do whatever service we were speaking about, then most likely if there's another situation like that, say it wasn't for mowing the lawn, but it was for something simple, it was to cut your trees, most likely the judge is going to rule that there was a binding contract. There was an offer and there was acceptance via the text message. So the judges won't deviate very much from their decisions. If they rule a certain way, then they're probably going to stay consistent and rule that way for the situations in the future. Now the courts, they rarely change precedents. They rarely say, you know, although there was an acceptance over here, these are the same situation, same circumstances, but I'm not going to rule the same way. Then that's usually, if it's very, very similar, it's almost the same thing, they very rarely deviate. However, if they do, there's most likely certain issues or certain facts that change the scenario just a little bit to say these two are not the same situations. Therefore, I'm not ruling the same because it's not the same. However, they do also, if it is the same, they if there's major circumstances to compel a change in the interest of justice or society, or culture wants a certain change, then the judges will likely do a 180 and change the way they rule on the same situation, because society or for the interest of justice that needs to be changed. Now slide 19, this is our final slide, I promise. It's going to discuss, kind of wrapping up again, chapter 1. We want to think strategically. We want to know the law. We want to know how to apply it to our situation or to our company to add value or to create value for the company. Now, here are some examples of companies adopting 4 of these strategies that we discussed earlier in the previous slides. First one was non-compliance. An example of this is there's shipping companies in New York. They just park illegally and simply they just pay the fines as part of doing business. They realize that, you know what, if the cost to park somewhere else and then unload the product and then ship it to the harbor or to the dock where it's supposed to be delivered, that's too much money. It's might as well let's just park illegally and pay the fines. They just do the cost value analysis and they say, you know, it's better if we just park there, pay the fines, unload it, and then leave. It's worth it. It's just cheaper that way. Then that's non-compliance, and then just pay the fines. Now the second one is avoidance. They're trying to add value by trying to avoid certain traps. There is a large multinational corporation, so a large U.S. company. It merges with a smaller foreign rival, with the smaller foreign rival surviving. So when they combine, one of them has to survive and one company has to die because they became one company, so the two of them can't be alive. So the larger U.S. one combines or merges with the smaller foreign one, and the foreign one surviving. So therefore, they avoid paying U.S. income tax on future earnings because it is a small foreign company now. Third one is prevention. The widespread of legal disclaimers in consumer contracts. That is the way companies are trying to prevent lawsuits or losses that way, to kind of push out the liability and leave it on the consumer by signing waivers. Now the last one is the value creation. The use of valuable trade secrets such as the formula for Coca-Cola or the algorithm for Google search engine. Now those are ways to create value, know the laws, know how to apply them, and then use how to protect them. So using patent laws, copyright laws to work, create a product, and then how to protect it is a valuable way to add value to your company. So thanks for participating and watching the video and hopefully reading the required reading. But this concludes the presentation. Next week I'll post another video. It will be on chapter. I believe it's chapter. Next week will be week 3, and it's going to be chapter 4, dealing with the courts. So again, I would, in order to understand or to follow the video and get as much substantive and get as much information and knowledge as possible, I would highly encourage you, or I do highly encourage you, to read the chapter before and then see the video, and then perhaps maybe go back and look at your notes or look at the videos, jump back and forth to whatever time you need to. But thank you very much. I look forward to next week, week 3. I'll be discussing chapter 4, courts. Thank you.